Issue: the purchase price of the home was $325,000 with a $5,000 earnest money deposit. The buyer was notified that the appraisal ordered by the lender was for only $310,000. The buyer did not cancel the transaction within 5 days. Due to the low appraisal, the buyer was unable to qualify for financing by the closing date, and the seller issued a 3-day cure period notice. During the 3-day cure period, the buyer delivered a notice of unfulfilled loan contingency and also a notice of cancellation due to the appraised value of only $310,000. Is the buyer entitled to the return of the earnest money? Answer: no. First, under Section 2L of the contract, the buyer waived the appraisal contingency because the buyer did not cancel the contract within 5 days after notice of the $310,000 appraisal. Second, underlined Section 7B of the contract, the buyer's inability to obtain loan approval due to the waiver of the appraisal contingency gives the seller the right to the $5,000 earnest money. Issue: although the buyer has qualified for the loan, the buyer's out-of-state lender still has not funded the loan 2 weeks after the scheduled closing date. The seller has been patient, but the seller now wants to cancel the 2005 contract. Is the seller required to furnish a 3-day cure period notice to the buyer? Answer: yes. If one party fails to close the transaction by the scheduled closing date, the other party must deliver a 3-day cure period notice to the other party, even if the failure to close is more than 3 days after the scheduled closing date. A buyer and seller had agreed upon a close of escrow date of October 12th. The seller lived out of the country. The seller was not able to overnight the executed closing documents by October 12th, and therefore offered the buyer prepossession. The buyer agreed to the offer of per possession. Additionally, an addendum was drafted extending the close of escrow to October 18th. The buyer and seller both signed the addendum. The buyer moved into the property and issued a cure notice to the seller on October 14th for failure to close escrow. Can the buyer issue a cure notice to the seller for failure to close escrow? Answer: no. The buyer and seller both signed the addendum extending the close of escrow date to October 18th. Therefore, no party is in breach at this time. The buyer and the seller entered into a purchase and sale agreement through which the buyer made a $1,000 earnest money deposit. Subsequently, and in exchange for extending the close of escrow date, the buyer and the seller agreed to the following language in an addendum to their contract: buyer to deposit $5,000 additional earnest money into escrow to be applicable to the purchase price and released to the seller. The buyer was unable to obtain a loan. Therefore, the title company released the initial $1,000 earnest money to the buyer and the $5,000 to the seller. Did the title company wrongfully release the additional $5,000 deposit to the seller? Answer: probably not. The language contained in the addendum directed that the additional $5,000 earnest money be released to the seller. Based upon this language, the title company likely believed that the seller was entitled to this money as consideration for the extension of time to close escrow. Thus, as the escrow never closed, the additional earnest money deposit could not be applied to the purchase price and was properly released to the seller as directed by the addendum. The seller of a residential property issued a cure notice to the buyer on November 7, 2012 at approximately 8 UMIR p.m. The cure notice was issued due to the buyer's failure to close escrow on the agreed-upon date of November 7, 2012. When must the buyer close escrow for the property, such that the buyer is not considered to have breached the contract? Answer: pursuant to Section 7A of the Residential Resale Real Estate Purchase Contract, the contract, if the non-compliance is not cured within 3 days after delivery of the cure notice, the failure shall become a breach of contract. Similarly, Section 8I of the contract provides instructions for calculating time periods and reads, in part, In computing any time period prescribed or allowed by this contract, the day of the act or event from which the time period begins to run is not included, and the last day of the time period is included. Further, pursuant to Section 8H of the contract, all references to days the contract shall be construed as calendar days. In this case, the seller delivered the cure notice on November 7, 2012, which was the same day the close of escrow was to occur. In calculating the time period in which the buyer had to close escrow, the day of delivery of the cure notice is not included. As a result, the buyer's cure period commenced November 8, 2012, and ended at 11:59 p.m. on November 10, 2012. Therefore, the buyer's failure to close escrow on that date constitutes a breach of the contract. The buyer's $1,000 earnest money check bounced. After several attempts to get a new $1,000 earnest money check from the buyer, the seller delivered a 3-day cure period notice. The buyer within 3 days delivered a new $1,000 earnest money check to the title company, but this new $1,000 earnest money check has also bounced. Can the seller cancel the contract now, or is the seller required to issue another 3-day cure period notice? Answer: after 2 bounced $1,000 earnest money checks, the seller can probably cancel the contract. A court would probably not require the seller to further engage in an exercise in futility. Pursuant to the AAR Residential Resale Real Estate Purchase Contract, the purchase contract, the close of escrow date was scheduled for July 18, 2014. On July 21, 2014, the seller issued a cure period notice to the buyer pursuant to Section 7A of the purchase contract for the buyer's failure to close escrow and failure to sign loan documents. The cure period expired without the buyer signing loan documents and closing escrow. After the cure period expired, the seller received an unfulfilled loan contingency notice from the buyer. Is the seller entitled to the earnest deposit? Answer: yes. Section 7A of the purchase contract provides that if a noncompliance is not cured within 3 days after delivery of such notice, the failure to comply shall become a breach of the contract. Here, the buyer failed to close escrow on July 18, 2014, the scheduled closing date as prescribed by Section 1D of the purchase contract. As a result, the seller provided a cure period notice allowing the buyer 3 days to cure as prescribed by Section 7A of the purchase contract. The buyer failed to close escrow within the cure period. Instead of closing escrow, the buyer could have alternatively provided an unfulfilled loan contingency notice pursuant to Section 2C of the purchase contract within the 3-day cure period, provided the reason for failure to close was loan disapproval without prior to document PTD conditions. Unfortunately, the buyer failed to either close escrow or send the unfulfilled loan contingency notice within the 3-day cure period. As such, the buyer breached, and the seller is entitled to the earnest deposit.